procession is led in by the Deputy Registrar, Senate Matters, Mrs. Comfort Ehigiato. Vice Chancellor's procession, we have Directors of Programs, Directors of Institutes, Directors of Academic Units, the Deans of Faculties, the Dean of Students, the Dean of Postgraduate Studies, the Provost College of Medical Sciences, the Principal Officers of the University, the Vice Chancellor's procession. We shall now take the first and second stanzas of the national anthem, followed by the Uniben anthem. Transformational, indomitable, indefatigable Vice Chancellor, very distinguished Professor Lillian Imwetoyan Salami, here ably represented by the Deputy Vice Chancellor Academic, Professor Ray Ozolwa. I thought you would put your hands together. She may not be here physically, but she is here with us. Another round of applause for the Vice Chancellor, please. Former Vice Chancellors of our university and heads of institutions, my Lords High Court judges, my Lords Spiritual, other principal officers of our great university, the provost, deans, directors, the inaugural lecturer and family, professors emeriti, other esteemed scholars in the auditorium, top government functionaries, your Royal Highnesses, greatest UNIBEN staff and students, invited guests, gentlemen of the press, distinguished ladies and gentlemen, good afternoon. Welcome to this 329th inaugural lecture of the great University of Benin. Please clap for UNIBEN. Today's lecture is special, not only because it is to be delivered by a scholar of exceptional candor, it is also special because it is the last in the tenure of our phenomenal Vice Chancellor, Professor Lilian Salami. Again, it is special because this is the number 100 to be delivered under the highly resourceful administration. The lecturer is a professor of human rights law, Professor Victoria EREKPITAN, ONUOHA. The topic is the us in the law and the dynamics of equity in an idiotic legal system. May I now respectfully invite the Registrar of the University and Secretary to the Governing Council, Mr. Ademola Bobola, to formally introduce the Vice Chancellor and the Vice Chancellor's procession. Mr. Registrar.
Thank you. Madam Vice Chancellor, ably represented here today by our Deputy Vice Chancellor Academic, Professor Ray Ozolwa. Distinguished members of Vice Chancellor's entourage, I want to plead that I be allowed in my usual manner to abide by the protocol as duly established by the university's PRO, not to waste our time going over all the protocols all over again. All courtesies, however, duly extended. It is my singular honor to perform this role by introducing the Vice Chancellor. I've said we can't introduce a Vice Chancellor really. All I need to do is just to present her to this very distinguished audience. And we've been doing that over and over. This is the 100th as we have had to be done during her own time. I think it's a milestone that we need to clap for. Each time Madam Vice Chancellor is there, she looks towards this direction, and only once in a while towards this end. We see the ancients there, the ancient of this, as far as academia is concerned. And I'm sure they know that within an administration is unusual to have hundreds in a particular administration. I think it's the first time that we are witnessing that kind of experience here. Madam Vice Chancellor, as we know, just dropped some of the positions she was holding at the national level. Prior to this time, she was Chairman Committee of Vice Chancellor of all Nigerian universities. We had 273. Later it became 274. And she was the one who presided over, but she has just handed over. And till now she remains the Vice President, Association of African Universities. That's all over the whole of Africa. We should give her a round of applause for that. A woman of distinction who has projected women issues over and over, and not only that, promoted scholarship, development within the academia and even beyond. And of course, she's also close to tradition. Apart from the Benin tradition for which she's known, she's Oganese of Igara land and the Yeye Meso of Ondo Kingdom. I think we should give her a round of applause again for that. There's no doubt that she has transformed this university to another level, thereby leaving a very big shoe for another administration to fill in. I'm sure by the time we have the next administration, we want to continue along that pedestal. So once again, I want to formally present her, Professor Lillian Imati Salami, our dear Vice Chancellor. There is no time we spend on her that is too much, because she has done so much and she's still very much alive. It's not when somebody has passed on, you start to say many beautiful things. So when she's still there and she's following us online, we should be able to say all the beautiful things she has done, so that we can encourage the next set of leaders to fall in. Today, as we have heard, we have with us a distinguished professor of pharmacy, fellow Pharmaceutical Society of Nigeria, deputy vice chancellor, academic of our great university, Professor Ray Ozolua, standing in for the vice chancellor. Of course, we have with us another distinguished professor, this time in pharmacognosy, Professor Buliamini Ayinde, Deputy Vice Chancellor Kewa Campus. And we have the representative of our acting bursar here today is Mr. G.A. Omoregbe. The keeper of our books and scholarly publications, the acting university librarian, Walter Toyo Megicin, Esquire. The provost of our very reputable College of Medical Sciences, Professor Wilson Sado. And of course, the acting dean School of Postgraduate Studies, Engineer Professor S.A. Aliu. The #1 student of campus, a very distinguished professor of economics, Dean Student Affairs, Professor A.C. Igodao. And of course, somebody we were just discussing a few moments ago that we need to pay consultancy fee to have him at inaugural lecture, but he has to be here today. He's the host dean, the Dean Faculty of Law, where we're having the inaugural lecturer today, Professor Ikowosa Omori. And of course, the Dean Faculty of Agriculture, Professor David Izeko. The Dean Faculty of Arts, who is performing this role for the very last time. He has already paved the way through an election to welcome another very distinguished professor to head. But currently and today, he has the shots and he can call the shots. Professor Constantine Yuka, Dean Faculty of Arts. The Dean School of Basic Clinical Sciences, Professor V.J. Ekanem. And the Dean School of Basic Medical Sciences, Professor Freddy Agureo. The Dean School of Dentistry, Professor F.O. Omoege. And the Dean Faculty of Education, Professor Kingsley Omorogiwa. The Dean Faculty of Engineering is represented today by Dr. C.I. Eboigbe. The Dean Faculty of Environmental Sciences is ably represented here today by the man we always see. This time around we want your Dean to come again. You have been coming. Dr. Jeff Uwodo. Please let's give him a round of applause. He's a very distinguished academic. The Dean Faculty of Life Sciences, Professor Jerry Urui. The Dean who has just flown in, just because of this inaugural lecture and other assignments, the Dean Faculty of Management Sciences, and he has a lot of goodies to share to support the inaugural lecturer today. Professor A.O. Inofe, the Dean School of Medicine, Professor W.O. Osaro Giago, and of course the Dean Faculty of Pharmacy, Professor A.C. Okwara, the Dean Faculty of Physical Sciences, I hope we won't laugh too much after this, Professor E.O. Ayowi. We have with us today the Dean Faculty of Social Sciences, and who is possibly, from my own reckoning, attending this as a brand new Dean of that faculty. And we have to congratulate you for that. Professor Omori Osunde. And we have with us today the Dean Faculty of Technical and Vocational Education, the Dean that has come out of the very powerful hand of the Dean of Education. Professor E.E. Uko Avioma. We have with us today the Director Center for Distance Learning, Professor O. Aigovo. And we have with us today too, Director Center for Entrepreneurship Development, Professor E.E. Ugiagbe. Professor Hassan Ohena is the Director Center for Educational Technology. Professor Anthony Ogbebo is the Director of IPTTO Office. Professor Mrs. Ijeoma Obo is the Director of Tetford Center of Excellence in Aquaculture and Food Technology. Professor Mrs. Ujiro Igudu, the Director of SDG, Sustainable Development Goals. Director, University Quality Assurance Office, Professor Peter Sede. The former orator, but always an orator, giving the microphone, we won't leave it here today quickly. The University Advancement Office Director, Professor Edi Eragbe. We have with us the Director, Institute of Child Health of this very great university, Professor Mrs. Ayebo Sado. Well, you may not see her direct, except the camera will pick up, and I hope the camera will do that. Blessed are those who have not seen, yet believe. Director, Student Guidance and Counseling Unit, Professor Mrs. O.N. Aye. And the Director, Institute of Public Administration and Health Services Management, all the way from Ekenwa Campus, Dr. John Osagai. Well, this is the one that will make us laugh so much, but I will always try, because my teacher has taught me several times, but I'm still learning. The Acting Director, Center for Maritime Studies, Dr. Efo Uwohire. And of course, we have leading the Vice Chancellor Central today, the Deputy Registrar in charge of Senate Matters, Mrs. C.I. Egiato. Please, let's give all of them a round of applause. Today is a very significant day in the life of this university and in the life of the inaugural lecturer. And I'm sure the Vice Chancellor has a very robust address to present. It is therefore my singular honor to call on the Acting Vice Chancellor to present this address.
Greatest Uniben. Greatest Uniben. Can you be louder? Greatest Uniben. Good evening, professors, ancient and modern. To this God's academic temple, I also greet other distinguished persons here. Please permit me to align by the protocols already established. I've often been asked why align, not stand. And I tell them my weight is light, so standing will not be very effective, will not be consequential. The chief priest, our vivacious, delectable, transformational Vice Chancellor, Professor Lilian Imotian Salami, is unavoidably absent. But she has asked me to send her very warm greetings to everyone here present. Ladies and gentlemen, distinguished audience, I proceed to read her address verbatim. And she says, "It is with great delight that I welcome you all to the 329th in the inaugural lecture series of the University of Benin. Today's lecture is the third in the Department of Private and Property Law, 9th in the Faculty of Law, the 100th and the last that will be delivered in my tenure as the Vice Chancellor of this university. I wish to thank all staff, students, and other stakeholders whose cooperation has resulted in the high number of inaugural and valedictory lectures that have been recorded within the lifespan of this administration. I'm pleased to inform you all that in activities for the 49th and 50th convocation ceremonies will commence on Monday, 18th November with press briefing, and we end on Saturday, 23rd November with the conferment of higher degrees, honorary degrees, professors emeriti. I therefore use this opportunity to invite you all to the ceremonies. Ladies and gentlemen, it is my pleasure to introduce our lecturer for today. She is Professor Mrs. Victoria EREKPITAN, ONUOHA. The title of our lecture is "The Ass in the Law and the Dynamics of Equity in an Idiotic Legal System." Professor Mrs. Victoria EREKPITAN ONUOHA was born on 30th November 1964 in Okenu side, Ora, to the family of late Chief Simeon Iziochai Ayeni and Mrs. Grace Agbamoyi Ayeni of Okenu side, Ora, Owan West local government area of Edo State. She attended Owato Primary School, Oke-Ora, from 1971 to 1977 for the first school living certificate. She had her secondary education at St. Mary's Girls Grammar School, Eme-Ora, from 1977 to 1982, where she obtained the West African School Certificate. Between 1983 and 1985, while studying for her advanced level certificate in the University of Ibadan, she worked briefly as a clerical officer in the National Archives, Ibadan. Thereafter, she gained admission into the University of Ibadan affiliated Federal College of Education, Okene, to study English and music in 1985 for the National Certificate of Education. Following her excellent performance in the Joint Admissions and Matriculation Board as the second highest scoring candidate, she was admitted into Bende State University, now Ambrose Ali University, Ekpoma, in 1988, from where she obtained the Bachelor of Law degree in 1992. I thought that she orchestrate an applause. She proceeded to the Nigeria Law School, Victoria Island, Lagos, where she obtained her professional qualification in law and was called to bar in 1993. She did her mandatory one-year National Youth Service in Mike Ozekome Chamber, Benin City, between 1993 and 1994. Thereafter, she worked in J. Omohezoge and Co. law firm in Benin City. Professor Mrs. ONUOHA obtained a Master of Law degree in 1998 from the University of Benin, postgraduate diploma in Human Rights Law from the American University, Washington College of Law, Washington, D.C., USA in 2008, and PhD in Law in 2008 from the University of Nigeria, Nsukka. She joined the services of University of Benin as lecturer 2 in the Department of Private and Property Law in January 1998 and rose through the ranks to the position of professor in 2015. Professor Mrs. ONUOHA has held several academic and administrative positions and served in several committees within and outside the university. I'll give examples. Public Relations Officer, National Association of Women Academics in UBEN Chapter, 2000 to 2003. Member Orientation Committee for this university, 2000 to 2005. Secretary, Center for Gender Studies Proposal Drafting Committee in 2003. Member Central Entrance Examination Committee, 2010 to 2014. Lecturer in charge, Department of Private and Public Law, 2012 to 2014. Acting Head, Department of Private and Public Law, 2015 to 2016. Member, Committee on Regional Fulbright Workshop and Education, USA College Fair, 2016. Head, Department of Private and Public Law, 2017 to 2018. Member, Part-Time Program Monitoring Committee, 2017 to 2019. Chairman, Student Certificate Screening Committee, 2020 to 2021. Chairman, Ethics Committee, 2020 to 2023. Legal Advisor and Chapel Secretary, All Saints Chapel, University of Benin, at various times. Pioneer Dean, College of Law, Glorious Vision University, Ogwa. I thought that should elicit applause. Distinguished ladies and gentlemen, I said I was going to give examples. Now imagine if I didn't have to give those examples and I had to go through the entire thing. Professor Mrs. ONUOHA belongs to several professional bodies and associations. Example still, member, International Bar Association, member, Nigeria Bar Association, member, Nigeria Association of Law Teachers. She has been honored with the following awards. Fulbright Visiting Scholar to American Washington College of Law, Washington, D.C., USA. Award for Academic Excellence by Uniben Students Union in 2009. Commendation by Uniben Management for successfully organizing the Regional Fulbright Workshop and Education, USA College Fair in 2016. Professor Mrs. ONUOHA has served as external examiner to other academic institutions. She has over 40 publications comprising books, chapters in books, technical reports, and articles in reputable peer-reviewed local, national, and international journals. She has attended many local, national, and international conferences as well. She has successfully supervised over 40 masters and 8 PhD theses in law, and five of our former postgraduate professees are now professors in their own right. She has been a researcher for at least 3 agencies of the United Nations, including United Nations Office for Drugs and Crime and United Nations Interregional Crime and Justice Research Institute. She has also worked with agencies such as International Organization for Migration and the Work Free Foundation. Professor Mrs. ONUOHA has the following hobbies. She loves baking, watching sports and crime movies. And I can imagine why for a born-again Christian to be associated with watching crime movies. Well, somebody needs to be streetwise, isn't it? How do you become streetwise? By knowing what those persons do and how they do those things. Round of applause. She is a Christian of the Church of Nigeria Anglican Communion, and she worships at All Saints Chapel, University of Benin. She is married to Surveyor Vincent ONUOHA, and I see the man beaming with smiles from molar to molar. And the union is blessed with children and grandchildren. Ladies and gentlemen, distinguished audience, it is now my pleasure to, on behalf of Madam Vice Chancellor, invite Professor Mrs. Victoria EREKPITAN, ONUOHA, to deliver her inaugural lecture.
Madam Vice Chancellor, distinguished audience, I must apologize that I'm terrible with protocols. So will you please permit me to adopt the one already established. Thank you very much. Before I commence, I have a few remarks to make quickly so that we can better appreciate. Thank you. As has already been said, my name is Victoria ONUOHA. I used to be Mrs. Victoria Carlo, and a lot of people have been wondering what is responsible for the migration. Did she divorce her husband and remarry or something? Well, I'm not the one to answer that question. The owner of the former and latter names is here. So just ask, I'm just a shell, so I follow my owner anywhere it goes. Thank you very much. I stand here today not as he that willeth or runneth, but he that God has shown mercy. I didn't set out to be a teacher. I set out to be a big lawyer of the kind that my father used to dream about. And in fact, he used to work as a court interpreter. And he will come home, he will regale us with exploits of big lawyers like SIO, Giramu, Barrister Legbe, of blessed memory. And I got so keen, interested in becoming a lawyer. I did become a lawyer. But rather than go into advocacy, which I did briefly, faith, or rather the hand of God, brought me into teaching. They say that God who rules in the affairs of men know our end from our beginning. My husband conspired, directly or indirectly, with the then dean of the faculty of law that we used to call the emperor, Professor T.B. Ogiame, who refused to sign my master project unless I gave him an application to become a lecturer. I told him I didn't want to teach. After all, how much are you paying? 5,000 or less? I was earning way more than that in practice. But to call this long story short, my husband just said, why don't you just try it for a while? Ogame extracted a letter from me, and carried it to Professor Nokraye, and within 1 week, I had an appointment letter on my desk. But I must confess that the conspiracy worked out because I found great satisfaction in imparting knowledge to others. Another quick point I want to make is that these days they tell you that you must be an expert or you must specialize in a particular area. I'm actually an expert in human trafficking laws and policy. But I chose an area, or rather, when I came in here, I was assigned to teach a course that many think, or many are of the opinion is difficult. The students here will tell you, when you experience equity, you will give me a name, whether I like it or not. You're either going to say I'm a witch, or you will say Mama Equity, depending on whether you pass or you fail the course. That notwithstanding, I'm not going to waste our time today. And I want to ask the question, why are we here? When I get to the slides, I will show you the lecture outline. We're actually here to discuss this popular saying that the law is an ass ass. You might have heard that. Many people do not even know why that slogan is there. Why is the law an ass? Why do you say the law is an ass? Okay, I will tell you a quick story. Maybe it will position us better. Now, how many of us have read Oliver Twist? Thank you. So we are familiar with the story of Oliver Twist. And what we know best about Oliver Twist is Oliver asks for more. But I'm talking about the legal one today. A crime scene occurred in Oliver Twist that many tend to overlook. Here was a couple. A man who was married to an overbearing wife. In other words, it was a woman that was wearing the trouser in the house. And they had charge of Oliver. The locket that would have established his parentage, the woman of the house stole it because he wanted Oliver to remain an orphan. Stole it, had the locket destroyed. And the husband was standing right by her when the locket was destroyed and he did nothing. By the time the matter came to light, they brought them to the courts of sorts those days. And he waited for his wife to go outside after the confession and asked the judge, I hope this small problem is not going to affect my job. That was saying you can count on it to affect your job. He said, but I didn't do anything. He said, you did everything wrong. Because the law presupposes that you are even the guiltier. If there's a word like that, you are the more guilty of the two. He said, why? He said, because in the eye of the law, you are criminally responsible for the actions of your wife. The poor man confused said, what? How can I be responsible for the actions of my wife? You want my wife to beat me at all? He said, well, if that is the eye of the law, then the law is a ass. He said it, not me. The Lord is a ass, the law is a idiot. And I wish that the law were a bachelor. Because if he was a bachelor, the law must be a bachelor. Because if he were a married person, he will know the trouble that I'm going through in my house and will not hold me accountable for the actions of my wife. That is the short story of. So, why is the law an ass? I would say that no man-made law is perfect. By the way, before I continue, I must pause. I'm sorry. This lecture is titled The Ass in the Law and the Dynamics of Equity in an Idiotic Legal System. And it is dedicated to the memories of our beloved and cherished daughter, Ruth Ejimole Inekame Kalu, to my father, Chief Simeon Izyokai Ayeni, and to my substitute father and brother, Evangelist Emmanuel Eboreme Ezomo. They have all transited to the afterlife. We are going to deliver this lecture in under three main headings: the introduction, and then the real body of the work, which is the ass in the law and idiotic legal system. I will conclude with recommendation and conclusion. I will crave your indulgence. The time given to me is not too long. When you have a copy of the text with you, everything you want to know about this lecture today is contained therein. So we're just going to make brief summaries. Now, there are two systems of law that as a country of the Commonwealth that once belonged or that was once colonized by Britain that we run in this country. And what are the laws we are dealing about? When you say the law is an ass, we are talking about the totality of all the laws, irrespective of the source. It's a system of its own. But you know what? The default settings of that system is popularly considered asinine because of the way it functions. So they had to invent another system that is called equity. And for computer people, you will know what it means to troubleshoot errors. So equity was invented to troubleshoot the errors of the common law. That law was inherently defective. Everything was wrong with it. Why? because it did not espouse the principles of justice. Justice not according to law, but justice in every sense of the word. The text you are seeing in red was the quote given by Mr. Bongo in the Oliver Twist character that I had. And that his experience, by his own experience, he reasoned that, okay, if you say that I am responsible for my wife's action, what kind of reasoning is that? In other words, something must be wrong with the person that made that law, and something is wrong with you, the judge that applied it. So if you look at the picture on the screen, that's probably what Mr. Bombo had in mind. That the ass, you can see the ass is wearing a wig, and is wearing a lawyer's outfit, right? I'm not going to interpret the remaining one for you. Just use your head, or use your, Thank you. I won't waste time defining the key terms. Some are important anyway. By the way, do we all know what an ass is? An ass is a donkey. We know it as a donkey. It's the English people that call it an ass. And it is stereotypically associated with stupidity and idiocy, according to Humby 2020. And what does it mean to be an idiot? To be an idiot means that you are below average intelligence, right? Yes. But when you apply idiocy to a system, it means that a person's system rule or law or decision is devoid of rational thought or common sense in functionality and reasoning. The person is not reasoning properly. For law, anybody can define it. But for our purpose today, it simply means it's a set of obligatory rules, regulations derived from several sources that are legal, and the purpose of the law is to maintain societal order, according to Williams 1945, Lord 1972. Equity is another system of law, like I mentioned earlier, and its purpose is to cure the idiocy of the law, according to Yakiome and Kalu 2006. A legal system is everything that has to do with the substantive laws of a country, as well as the institutions that manage and run or administer those laws. Then common law is the real problem we are dealing with today. Common law originated from England, from the customs of the people, and then were later developed by a set of judges. And those judges, the way they functioned and the kind of decisions that they made, the way they treated human beings, was so bad that even the great Lord Denning admitted in the case of Seaford Court Estates Limited and Asha that the law is the law even when the law is an ass. In other words, until a law is repealed, it remains the law and everybody is subject to it. So what does it mean to, why do we say that the law is an ass or that the legal system is idiotic? I said that any reference to the ass in the law is a reference to the quality of the law itself, either a reference to the quality or the inflexibility of the law. Rigidly, you stand on one point, or even when it is flexible, it is applied in an unfair manner. That's ONUOHA 2008. And when there is a failure to apply reason, equity, and fairness in balancing the scale of justice, then there is an ass in the law, Kalu 2004. For Makova, he says that for him, the ass in the law is, quote, with all due respect to my colleagues present, the arrogance, rudeness, and thoughtless ways in which courts are run by judicial officers. That's his opinion. And according to Kirk, he says that the ass in the law is, quote, the foolish mortals who practice as attorneys and advocates, because they are led by factors other than the rule of law. There are other opinions on the point. Like I said earlier, you will find them in the text. Now, how did the ass get into the law? The ass got into the law because of the human beings that manage the law. The judiciary has been our problem from time immemorial. I told the PRO this morning, I didn't invite any judge because this matter is about them and I don't want to be cited for contempt. The judiciary has been a problem right from the days of the common law. It was an elite and powerful and corrupt group of judges, according to Godley and Vermeuren in 2006. And then, you know what they did? They were the ones making the law, not even the parliament. It is what they interpreted the laws to be, or what their decisions that became law in its own rights. And then they worshipped what we call forms and precedents, like the Chinese worship their ancestors. I hope you know that the ancestors of Chinese are deities in their own right. Oyakiomen and Kalu, 2006. So their entire approach to the administration of justice was less than desired. They put the law in a straitjacket like you would do Hannibal. And then in their wake, they left many wounded and frustrated litigants who were without justice. Now these systemic problems are fundamental. They remain in the common law system. Every country that runs the common law system goes through this problem. And another problem, apart from the fact that they had rigid technical rules and procedures, the problem of corruption has been there. Those judges of early times took instructions from the king or members of the king's council or any other powerful person in the society. So it was a case of the rich against the poor. We still have that problem today with us. I hope you know that. According to Ogbile Akani, he says that when men have done wickedly, they will say, go to court. What are you doing? In other words, they are telling you that just do your worst, because it's my guys that are in the court. I'm going to give you only one case to explain. There was, I don't know if many of us are familiar with the 2019 gubernatorial elections in Bayelsa State. I will only say that one. I don't want to go to Plateau. I don't want to go to number 4 in Imo. Let's just take the one that is close to us here, our neighbor. And that is the case of PDP against Degi. Eremeyo, forgive my pronunciation. That was a classic example of the systemic problems of the common law legal system in Nigeria, where courts focus on technicalities and forget the merits of a case. What happened in that case? The APC candidates, 2 of them ran on the ticket of the APC. I think the principal was David Leon, and this gentleman, Degi, I will call him Degi so I don't bite my tongue, was his deputy governorship candidate. They were validly nominated. And just before the elections, PDP ran to court and said that Degi, that is the deputy, gave false information to INEC. How did he give false information? That the declaration, from CF001, the declaration that all the information you have given is true and correct, that declaration was false because there were multiple names in his certificates. And I must sound a note of warning to our students and our parents too. You know, there are people who get multiple names. I know that my granddaughter has 22. As at the last count. And as they grow, they begin to pick and choose which one they want. Clearance officers here, you know what you deal with when people come for clearance. You now find a situation where they use one set of names in primary school certificate, another set of names in secondary school, and so on. They all create problems in the long run, right? And usually when you come, they say, okay, go and depose to an affidavit and do the right thing. This gentleman did everything. He had to depose to affidavit here and there. Correction, there were errors, spelling errors. Registrar was saying just now he's not good at pronouncing some people's names. So you can imagine if you have to write Osama Rama Osama Gyogowewi. I don't know how many of you can write that one. This was what happened to this gentleman. He had spelling errors in his names. He had problems with arranging his name. And then when he took a chieftaincy title, you know Nigerians will like chieftaincy titles. He now added his chieftaincy title to his official names. Fate caught up with him. Those who want to hang somebody, they will find a way of hanging the person. They now told the court that, okay, you know what, this guy is not the person, they didn't say he was not the owner of the certificate, so
They say he gave false information. And the courts that want to know better, rather than resolve any doubts in favor of this gentleman, they said he must have fraudulently, that he must have committed fraud. I will cut the story short so that we can save our time. Long and short of it all, and let the court disqualified him. He didn't just disqualified his principal, who didn't do anything. The only offense the principal committed was that he was guilty by association, just like Mr. Bombo and his wife. Matter went to Court of Appeal. Court of Appeal used a critical eye to look at the case and said, you know what? The process by which you even started this case was wrong. You used a process that does not allow for extraneous evidence. It's a process that involved only documents. They just told him, look at these documents, tell us what you think about it. The man said, look, these errors were not committed by me. These are my certificates. But he could only do that in his statement of defense. He could not call witnesses to come and establish who he was. The long and short of it all was that the Court of Appeal said, because there were contentious facts, the originating summons process that was used to commence it was wrong. Therefore, the accusing parties had no opportunity to prove their case beyond reasonable doubt as required in all criminal proceedings. But guess what? The elections held between Court of Appeal and Supreme Court that should have known better, left its own precedents, dealing with the fact that when you have matters like this, they must be proved beyond reasonable doubt. You know what the Supreme Court said? Supreme Court said, that it must be fraudulent for somebody to, they call the man a chameleon, to chameleonically use different names for different purposes. And they disqualified both of them. My question is, why would you disqualify the two of them? Because there is, that disqualification has no basis in law. And usually they will cite, sorry, I'm no longer using my slides. I'm just telling you the story of what happened. So I will get to the errors of the Supreme Court. The first error was that they unreasonably relied on forms and precedents like those old common law judges did. And what they did was to secure technical justice, what we call technical justice, anchored on unsubstantiated evidence, according to the case of Uwaboy against the state. And then, you know what they did? They now borrowed a precedent from the Court of Appeal. In law, there is what we call the doctrine of stare decisis, meaning that all lower courts must follow the decision of a higher court. The highest court in the land went to borrow from his younger brother. Right? The case they went to, they said, okay, this decision we are going to take today, so what do we use to back it up? They had to go to the Court of Appeal, where the Court of Appeal decided that, look, this gentleman committed fraud when that's in the case of DJ against Seleke Timibi. Now, in that case, the facts of both cases were not the same at all to have warranted borrowing that precedent. They were not the same. Why were they not the same? The facts, in the DJ case, the man deliberately committed fraud. How? In one affidavit, he said he was from Bayelsa State and was born in 1966. And in another affidavit, he said he was born in Delta State in 1971. Is that not a clear case of fraud? And he admitted that he was the owner of the two affidavits. But that was not the case here. This man is saying these are my certificates, and you didn't offer any evidence to the contrary. And then you disqualified him. Not just disqualified him. The Supreme Court now relied on what we call the legal fiction on joint tickets. They said because the two of them ran on the joint ticket, together they stand, together they must fall. Where is the sense in that one? Our laws give room that when you disqualify one, you ask him to pick another to join you. They say no. I dare say there was vested interest in that case. And that was why it turned out the way it turned out to be. The poor people went away without justice. And according to Okogbe and Arishe, he says that, thank you, the sections 182, subsection 1J and section 187 of 1999 Constitution that they usually use to support joint ticket is actually a fiction, and it is, quote, subversive of popular choice expressed through the ballot. What section 187 says is that any governorship aspirant who fails to nominate another person, his own nomination is not valid. This man nominated somebody, did he not? He did. That you disqualify the person didn't mean that he also should be disqualified. So you can see the unfairness in the entire system. I will go forward. Another problem we have is corruption within the administration of justice. In other words, the entire Nigeria is riddled with corruption. I dare say it. Right from this our university, if you are a clerk in your office and you collect money from students to do your official duty, you are corrupt. For judicial corruption is any inappropriate influence on the impartiality of the judicial process by any actor within the court system, PEPIS 2003 and 2007. So if you look at the screen, you will see the kinds of acts or omissions that compromise the integrity of the judiciary. And then Gang told us, in 2023, it says that in Nigeria of today, it is becoming easier to win elections through the courts than by popular votes of the electors. Two of us. Thank you. Now, what is equity? Equity is fairness. And, founded on the laws of God, divine law and morality. Whatever tells you that this is unfair. In fact, equity is tied to the conscience of man. And they had to invent this equity to cure the bad seeds. My colleague, Professor Dubois, used to say that you will plant bad seed and you will water the bad seeds, and it will produce for you whatever it is you were expecting when you planted it. Common law planted very bad seeds. But equity had to come and cure those bad seeds. And he did that in 3 jurisdictions, in the original, in the concurrent, and in the auxiliary jurisdictions. And what did he do? On the basis that every man is equal before God, equity decided that whenever there is a wrong, there must be a remedy. So it will do everything possible to right the wrongness of the law, according to Verdict 1938. Equity guarantees the right of access to justice based on the foundational maxim that where there is a right, there must be a remedy. ONUOHA 2008, Kalu and Stewart 2007, Okoje et al. 2004. And that maxim has universal application. The case you are seeing up there, the case of Marbury and Madison, was decided in the United States. If you think that it is only here that we have madness, madness is everywhere. Especially now that government has changed hands. This was a case of government changing hands from Republicans to Democrats. And somebody that had already been appointed as a judge could not get his letter of appointment because a new government came in and they sat on it. And he had to go to court to get his letters. Now, equity also is suppose, I'm going to be introducing suppose, guarantee the right to a level playing field. And that is to guarantee equality before the law, to guarantee the rule of law. To, bring government accountable, bring everybody accountable to the law. And it's supposed to ensure timeless justice delivery, dispensed by competent. I emphasize that, competent, because the quality of judges we are seeing these days, I won't say more. Ethical, neutral, independent officials. Kalu and Stewart 2007 and Kalu 2008. He will of course refuse to uphold unjust laws. Oyakhilome and Kalu 2006. And equity ensures the just and reasonable application of the law rather than just relying on the black letters, what we call the black letters of the law. Black letters of the law is anyhow you see the law, interpret it like that and apply it like that, whether or not it is fair. Oyakhilome and Kalu 2005, 2006, ONUOHA Nata 2013, 14 and 2024. Equity demands that you put your conscience to use. And unlike common law that is partial, equity is not partial. So that even when you come to equity with dirty hands, equity will send you back. It's not strictly a law lecture, so otherwise I'll be asking my students now that he who comes to equity, thank you. And I will give you an example of a case. There's the case that we call Highwaymen. Title of the case is Everett against Williams. It was decided in 1725. What happened in that case was some armed robbers went to steal. After they stole, you know there's no honor amongst thieves. How to share the loot became a problem. And one of them had the temerity to go and sue the other in court. And they wanted equity to come to their aid, Abi. People with dirty hands, you know, the court did not only just deny them justice, you know what he also did? He punished the lawyers that had the temerity to bring the case to court in the first place. So in all things, equity insists on substance triumphing over technicalities of the type that we witnessed in the D-Day case. Why did they even say Degi? What did they even say? They said the man didn't follow due process. The court didn't say he forged those certificates too. But they said that because he did not take the certificates back to the issuing institutions to correct, and that he didn't use what we call a deed poll to gazette the change of names or regularization, that it was suggestive of fraud, but there was no proof that such a thing happened. They even went as, those of you who are notaries public, please take note. The Supreme Court said that the notary public, before whom he deposed that affidavit, was faceless. Notaries public, they say you are faceless. That's what Supreme Court said, not me. They didn't recognize it. A denigration of the office of the notary public. So equity tries as much as possible to give reliefs where there have been injuries. And the reliefs that equity provides is, quote, as much as deserved. We call it the quantum merit reliefs. And it does that substantively as well as procedurally, right? So in the time of common law, they will give you the omnibus relief of damages. Whatever it is they do to you, you take money, it's enough, go and solve your problem. Equity doesn't do that. Equity will insist that, for example, in the law of contract, that if you have agreed on a particular item and you fail to supply that item, they will compel you to go and supply it. I want 30 bags of Dangote cement, and you go and bring 30 bags of Bua. The man says, Dangote cement, I want. You say, no, cement is cement. The common law will agree with him, oh boy, cement is cement now, take this one. In any case, what is the price difference? Oh, you take the extra. And that's what the common law will do. But equity will insist that an agreement is an agreement. Give him the Dangote cement or it's nothing. Then procedurally, what common law used to do, if they give judgment against you, to enforce that judgment becomes a problem. So they will just carry the man. They will go and put him. They go and forcibly put him in the other person's property to possess it. Imagine if you are dealing with a violent person, his fight not going to burst out there. Yes, that's what. And the law will tell you that we have done what we can do for you. Stay in his house there until he pays you what he owes. But equity will not do that. Equity will ensure that they either sell that property. They will help you to sell the property and give you what is due to you and give him the balance, give him the change. And then there's is this case of Redland Bricks Limited against Morris. We are used to this. Somebody was excavating minerals in a plot of land. Because of the digging downstairs, the side of the other man's land, the adjoining land, was slipping and collapsing. And they were saying that, okay, we will give you money to repair whatever damage will cause. They said no. The cost of the damage is more than the value of the land. So they had to get an injunction to restrain them from continuing with that. We are all very familiar with injunction. Everywhere you hear injunction, injunction, injunction. When somebody is threatened, whether real or perceived, they just run to the court. To the point that people now get injunction by 12 midnight, as if witches are going to a meeting. You go and get an injunction. Any small ex parte orders have become a subject of abuse in our courts. I won't go too deeply into that. I don't want to go to prison today. So, and this injunction could be mandatory, compelling somebody to do something, or it could be prohibitory, don't do it. And it can be issued at any time, either before the beginning of a case, in the middle of a case, or after a case. And that's what we have: interim, interlocutory, and perpetual. To close, before I give my recommendation, I want to tell you two stories, similar, but in different jurisdictions. Now, in the US, many of us may have seen that social media post. A man stole a loaf of bread, right? And when he stole a loaf of bread, they brought him before the court. And the court convicted him. He admitted that he stole, but he said he was hungry. That's why he stole, right? The judge said, well, I'm sorry, the law is the law. That's the black letters of the law. If you steal, you will pay the price for it. But he fined him $1. You know what the judge did? Recognizing the fact that there has been a failure in the system, he decided to pay the $1 fine on behalf of the accused person. And then he fined every other person in the court $1. He said, I'm fining you $1 because you allowed your neighbor, right? You allowed your neighbor to go hungry. Some of us will do it. Your neighbor will come to you and say, please, I beg, I never eat for 3 days. He said, it is well with you. If it was well with him, will he come to you in the first place? So the court recognized that fact and then told him that they now collected the money from all of you. Imagine collecting $1 for all of you here today. And they told the man, take this one, go and take care of yourself. Next time, don't steal. Now I want to go to my chaplain's village. Here in Nigeria, I was in court in Ekeadolo when I was still in practice in the area customary court. This man was brought before a court, charged with stealing. They asked him, are you guilty or not guilty? He said, my lord, I'm guilty with reason. In law, you can only have two pleas. Either you are guilty or you are not guilty. Everybody laughed, including the court. And then they remembered their position and quickly said, okay, let's hear this reason why you were guilty. The man said he had not eaten, himself and his family, they had not eaten for days. He didn't know what to do. And then he was walking around, he saw Gary they tied in a dryer, that local dryer. And then he took the Gary, he went to fry it and fed his children. Because said, what? So, of all things you could have done to get food, you had to be stealing. We're sorry, the law is the law. Because you stole, you will go to Benin prisons for 6 months, then you go and eat free beans and Gary. At least you will have feeding there and you will have free housing. Between the two judgments, which one do you think was humane? Thank you. So, the idiocy of the law is the one that was displayed by that court in Ekeadolo. While the judge who brought his own personal conscience into the law is what equity does. Thank you. Before I conclude, I want to make some recommendations. We can see from what I've been saying that the biggest problem we have that has called the integrity of the law into question is centered on the judiciary, ancient and modern. The judiciary is so powerful that they are the ones who will determine, who will even interpret the laws made by the legislator. So if a law is bad, even though their hands are tied, they cannot alter that law. They can interpret it along the side of the spirit of the law rather than the letter of the law. After all, the Bible says that the letter kills, but the spirit gives life. Thank you. Since the judiciary plays a pivotal role in ensuring that there is justice, judiciary must interpret and apply the law correctly. What happened in this case was that they deliberately misinterpreted the law. If they didn't misinterpret section 187, they would not have said that two of them ran a joint ticket. They must avoid technicalities of the kind that shuts out justice. And then they must free themselves from every form of correction, whether real or perceived. They must be above reproach, like Caesar's wife. Again, they must hold all other legal persons and institutions accountable. We are still looking for the governor of Kwara, ex-governor. Is it Kwara or Kogi? Thank you. The man walked with his two legs into EFCC office. They said, go, we are not ready for you. And then the minute in when they started shouting, we have declared this man wanted. What is the sense in that one? Who are you deceiving? Meanwhile, they gathered some small children of 13, 14, 15. They charged them for treason. Treason. Simply because they carry Russian flag when they didn't even know the meaning of the word they were carrying. Until the whole world started shouting before they now said, oh, hey, bring them. Come on, this is it's unfair. So, judges, in a sane system, the courts will hold the government accountable. They will hold all other arms of government accountable. Every public officer accountable. If you run foul of the law, you pay the price, without fear or favor. And at all times, they are supposed to protect citizens' rights and freedom, and they are not supposed to pervert justice under any guise. So our courts must, there must be a reawakening. There must be a re-evaluation so that they can do the needful and begin to sanitize an idiotic legal system. Again, we must bear in mind that before you begin to think that every judge is corrupt or it's idiotic, yes, we have very good sound judges, the ones who are above reproach in integrity, right? Some of those judges will deliver judgments according to law. When the letters of a law are clear enough, they are unambiguous, every judge is obliged to apply it. Okay? So, and because every judge is obliged to apply it, irrespective of his own personal opinions on the matter, litigants will have to take cognizance of the fact that the law could be an ass in certain circumstances, especially where it is devoid of any corrupting influences. Therefore, if you want to avoid the kind of technical pitfalls that the Bayelsa people fell into, you must work diligently to present their cases according to law. In my conclusion, the common law legal system was and is still inherently devoid of the rule of law, crippled by both the black letters of the law and then the inability or deliberate refusal of its administrators to separate substance from technicalities of the law. Our findings in all our research is that even though equity was invented to cure the inherent defects and other systematic disabilities of the law, it has not been able to achieve that purpose. And the reason why equity has not been able to achieve that purpose is because of the fallibilities and the frailties of those who administer the law. So when people believe in this popular myth that law can be equated with justice, they are mistaken. Law cannot be equated with justice. Justice goes beyond the law. It admits other considerations or moral grounds, or when you say God, you are saying that, okay, even though this is what the law has said, the Creator in heaven is looking at all of us. So justice is administered primarily according to the law, even if that law is flawed. So the people who administer it, irrespective of their own common sense, if the law is defective from day one, then you cannot alter that law on behalf of the legislature. That's what the court said in Aromolaran against Agoro. Indeed, in the case of poor man against Kilgore, the court noted, and I quote, "No man is perfect enough to bear a strict application of rules, and very few hearts are hard enough to enforce without flinching the letter of the law when it is the laws justly or unjustly. You know that there are human factors are at play in that regard. Those factors that I mentioned, those frailties that I mentioned, they have a much closer acquaintance with senselessness when somebody will deliberately decide to be senseless. Not that he does not know, but he deliberately decides to be senseless. Or he allows his political inclinations or political leanings to influence his decision. Or he has his his hands greased. Then we know that there is a problem. My last and final comment is that you see this ass we say is the ass is stupid, and the ass is actually a very intelligent animal, often in the region of ducks and dolphins in intelligence and in memory. So if you are equating the ass with the law, you are actually referring to the obstinacy of the stubbornness of an ass. An ass is naturally stubborn, especially when it is confronted with danger. We all remember Balaam's ass in the Bible, right? 3 times. Balaam was just beating the ass saw danger and ran away. So what is considered as stupidity is not actually stupidity, it is self-preservation. So, when the common law also corruptly or rigidly stick to certain forms and precedents, then you can equate it with the stubbornness of the ass, not necessarily the stupidity of the ass. So viewed in this context, Madam Vice Chancellor, we dare to conclude that the law is announced only if applied in the way Mr. Bombo, that henpecked husband, experienced and expressed it to be. When the agents of the law are either forced to or deliberately transform the law into a stupid and submissive ass, so that some litigants can ride roughshod over others. Madam Vice Chancellor, distinguished audience, my job today is done. Thank you for being so attentive and responsive. Can I acknowledge my mom? Yes, I crave the indulgence of Vice Chancellor. I know that I'm out of time, But I will do great. I brought my 96-year-old mother here today. No, leave her first. And I must acknowledge the husband of my youth. Together we have sailed the calm oceans and the rough seas of life. But God has kept us and has preserved us. Thank you very much for all the years. My brothers and my sisters are here. The Ionists are fully represented. My in-laws all the way from Lagos, they are all here. I want to thank everybody. Time will not permit us to take all the acknowledgements. If you look at the work, you will see the acknowledgement there. My mother, please permit me, I need to speak in a language she understands because everything has been going over her head. I said, no man. Hey, go away. She's been widowed for 41 years, but she has fought many battles to ensure that her children are who they are today. Thank you very much, everyone, for coming. God bless you.
Thank you, Prof. Please sit. That was very emotional, wasn't it? Thank you, Prof, for helping us to understand the razzmatazz in Nigerian courts. May I, at this moment, respectfully invite the Acting Vice Chancellor, Professor Ray Ozola, to recap the lecture.
Please listen. If you agree that this lecture has been very brilliantly delivered, please respond to the applause. If, however, you do not agree, you know what to do. What do? Go to court. You go to court. And when you do go to court, you will soon find that you lack the locus standard. And why so? Because issues of inaugural lectures are sui generis. Am I correct, lawyers? They are sui generis. Sadly, you will discover to your chagrin that the law is an ass and its interpretation is often idiotic. Distinguished ladies and gentlemen, my synopsis. Charles Dickens, in his book Oliver Twist, first published in 1837, stated that the law is an ass. That is, the law, when applied too rigidly or flexibly, can be blind to the realities on the ground and the requirements of justice. This is the kernel of Professor ONUOHA's lecture, which has very thoroughly interrogated the dynamics of equity in our legal systems. The lecturer told us that law is expected to have the characteristics of reasonableness and fairness that enunciate a notion of justice. Those who go to court expect justice, but rigid applications of the black letters, as she calls them, of the law, alongside corruption, has led to the substantial erosion of faith in the justice system. She posited that equity was invented to cure these systemic failures of the law and to apply some balm of sanity on the legal system. According to Professor ONUOHA, the principles and doctrines of equity are meant to guarantee equal access to equality before the law, as well as promote substance over legalism or technicalities. Unlike equity, that has more affinity with justice, law, she told us, when applied strictly without partiality or other moral considerations, may not necessarily achieve justice. Ladies and gentlemen, bearing this in mind, she has advised that litigants must acquaint themselves with the workings of the law and adhere strictly to its substantive and adjectival requirements when approaching the courts to enforce rights guaranteed by law. From her lectures, we are able to distill some recommendations. She has said that administrators should utilize relevant substantive procedural laws without fear or favor. She says administrators of justice must strive to interpret and apply law correctly and avoid strict and unreasonable adherence to technicalities of the kind. She gave us few examples, as in the case of Bayelsa, that shuts out justice. She drew a simile that applying law without the spirit behind its formulation makes it appear like heart without a soul. The judiciary, she says, must free itself from every form of corruption, real or perceived, to safeguard its integrity, impartiality, credibility, to position itself to hold all other legal persons and institutions accountable. In my view, the observance of these recommendations will kill the ass in the law and accentuate equity, as very brilliantly espoused by Professor Mrs. Victoria EREKPITAN, ONUOHA. Distinguished audience, let us validate her professorship with yet another thunderous round of applause.
The lecturer will step forward to be decorated by the acting vice chancellor as we invite the immediate family members. Yes. Other members will come on behalf of Mama. So the spouse, brothers, sisters will just stop it there. Yes, immediate family members. And so we recognize, please come up stage to join her for photograph. We recognize very specially some personalities here with us. We may not be able to call everyone's name, but please put your hands together for their darling husband, Surveyor Vincent ONUOHA. Put your hands together. Mama is seated. She's Madam Grace Ayeni. A round of applause for her, please. Other family members, Mr. Felix Ayeni, Mrs. E.A. ONUOHA, Mr. and Mrs. Godwin Ahio, Mr. and Mrs. R.D. Imuagene. Put your hands together, please. Let's also applaud Professor Emeritus and Mrs. Raymond Elayo, Professor Emeritus and Professor Mrs. T.O.K. Awudu, Venerable David Osaze Egbanusi, Chaplain of All Saints Chapel. Yes, I know you will applaud your chaplain. Professor Nosa Erafona, we welcome you, sir. We welcome Professor and Deaconess Mrs. Patrick Igbunovia JP. Welcome. We welcome the Dean of Arts Elect, Bishop Professor Benson Osadolo. We welcome you, sir. We welcome Professor Patrick Uwadia. We welcome Professor Rachel Uwadia. We welcome especially also the former Dean of Law, Professor N.A. Inegbedion. Welcome, sir. Put your hands together. I'm sure there are a lot of law students here and law teachers. So also do we welcome Professor Venerable Mon Wandiani. We welcome another former Dean of Law, Professor Violet Aigbohaibu. Welcome Professor and Professor Mrs. Omoti. We welcome Professor Evelyn Onwibe. We welcome Professor and Professor Mrs. Opute. We welcome Professor Mrs. Azuka Alutu. We welcome Professor Bright Bazwaye, also of Law. We welcome Professor Charity Emaviwe. We welcome Venerable Reverend Dr. Taiwo Olunlade. Venerable Solomon Maku, we welcome you. We welcome Venerable Dr. S.C. Ogbebo. We welcome you, Professor